Mr President, I rise to speak in relation to the Local Court Amendment Jurisdiction Bill. This bill, as we know, seeks to make changes to the jurisdiction of the local court, in particular so that matters relating to the new Commonwealth statutory tort for invasions of privacy, which was enacted December 2024, and the administrative review of decisions under Section 55 of the Privacy and Personal Information Protection Act and the Health Records and Information Privacy Act will be removed from the jurisdiction of the local court, and these matters will now only be able to be heard in the District and Supreme Courts, as well, of course, as the Federal Court and the Federal Circuit and Family Court. This change recognises that the new statutory tort for invasions of privacy is complementary to the existing law of defamation, which is an area of law that has never been part of the jurisdiction of the local court. And similarly, that the Supreme Court has traditionally heard matters of administrative review within its administrative law list, so this change in jurisdiction is soundly based. We are happy to support these changes. However, curiously, traditional allocation of jurisdiction was not the reason advanced by this government for the changes made in this bill. Rather, they relied on workload and the unpredictability of the workload to be created by the new Commonwealth tort and the predominantly criminal jurisdiction of the local court. The government is right to be concerned about workload. The workload of the court system is most clearly seen in court delays, and present indicators suggest a system which is overworked and overburdened. A Newcastle District Court judge, Judge Peter McGrath, has condemned wait times for trials in New South Wales as intolerable. He made these comments in November last year, when the earliest trial date for a murder allegedly committed in September 2024 was February 2026. As Judge McGrath commented at the time, quote, "It is intolerable in a civilised society that Australia claims to be that someone presumed innocent should have to wait 2.5 years before their guilt is determined," end quote. In 2022, in the wake of COVID, the coalition government allocated $148 million to address the backlog of cases in the district court. Then, the average time between arrest and sentence was 690 days, less than 2 years. Fast forward to the current Minns government, and we know that we have wait times far longer than this. Boxar tells us that in 2024, district court trials took 834 days to finalise. That is 109 days longer than in 2020. This is a sign of a court under significant workload stress. But the bill before us will not relieve this workload pressure and the consequent problems for members of the public seeking to access justice in our courts. In fact, it will add to the time delays by moving the privacy jurisdiction from the local court to the district court. This is even more curious considering the comparative delays in the local court. Turning again to Boxar figures, we learn that defendant hearings in the local court in 2024 took 275 days to finalise. A very long time if you are languishing on remand, but almost 600 days faster than the district court. So in the name of workload, this government is removing the privacy jurisdictions from the long delays of the local court to add pressure to the overwhelming delays in the district court. A curious approach indeed to relieving workload pressures. And no indication at all from this government that a more standard approach to relieving workload pressures may be followed, and the courts given more resources to cope with their burgeoning caseloads. And of course, all of these delays existed before the recent events at the Downing Centre, which will do nothing but add dramatically to current delays. The other reason advanced by this government to support the changes in this bill was that the privacy legislation was complex and that the local court has a primarily criminal rather than civil jurisdiction. We are happy to support this legislation. We acknowledge that the government is best placed to make decisions about allocation of jurisdiction and allocation of resources. We find it curious that the government approaches workload by moving work around rather than by providing adequate resourcing. However, we totally reject any suggestion that the tort of privacy is too complex for the judicial officers of the local court to consider. They may have a largely criminal jurisdiction, but the local court also has a significant civil jurisdiction. We have confidence in the capacity and ability of the judicial officers and recognise, as the government has with their decision to replace the designation of magistrate with that of judge, that the work of the local court has increased significantly in complexity and difficulty, and that these judicial officers have discharged their duties with expertise, as we would all expect. We look forward to monitoring the impact of these changes and the impact on our overstretched local and district courts.